Welcome back, and it's so good to be back on Opinion Court. I'd really missed this show. Well, tonight it appears that President Kenyatta is making good his threat to revisit the judiciary. From the fiery letter that the Secretary General of the Jubilee Party, Raphael Tuju, sent to the Chief Justice, David Maraga, accusingly saying, "You almost burnt the country." We are examining tonight the moves that the president is making and what they portend for law and order. But first, we want to give you a very first look at resignations of two powerful African leaders. South Africa's President Jacob Zuma resigned a day before Parliament debated a motion of no confidence against him. And in Ethiopia, strongman Prime Minister Haile Mariam Desalegn has resigned as both Premier and Chairman of the ruling coalition. No reasons were given, but is there a lesson here for the continent and for Kenya? We're talking to my guests in studio tonight. To the far right, Edward Kisiangani, our resident political analyst, and lawyers next to me, Steve Ogola and Kibe Mungai. Gentlemen, all welcome to the program. Straight off the bat, let me start with you. Kibe, is there a lesson for us in these resignations, and what do they mean?
Two different lessons. South Africa, it is the fact that despite many challenges South Africa has faced, its constitution is still working, ANC can ultimately call the shots, and they can still be able to solve the problem of bad governance through their laws. It's something to celebrate. Coming to Ethiopia, the Prime Minister, who is really a dictator, has been facing several challenges in the recent past. I keep saying, in Kenya, when two people are killed, it's big news on CNN and BBC and everywhere. But in Ethiopia, they routinely kill 500 people, 200 people, sometimes because of very simple reasons. But if it appears that, like, Desalegn is probably coming to the conclusion that it is not viable to govern Ethiopia that way and for long, that might be a good thing. But I also need to add about Ethiopia that the kind of ethnic politics that you have in Ethiopia and the narrow government that you have, where a very small minority with the control of state power has been calling all the shots in the face of widespread demonstrations that have been going on in the recent past. It is obvious that dictatorship is likely to collapse and has collapsed in many countries. And therefore, Ethiopia, to me, which I don't see like a viable state, is a state bound to, it's actually bound to be another Yugoslavia. I hope I'm wrong. But in my prediction, I see it going the way of Yugoslavia. And the main reasons for that is, is ultimately going to be that you cannot be able to govern people who wants to be free without any kind of consent, but through the exercise of state power alone.
All right.
That could be a big lesson.
Prof, lessons for Kenya, for Africa?
That is very good news for Africa. Apart from dancing, Jacob Zuma was not necessarily a very good president, but he was a dancer and a serial. You know, he liked what you called in the Shakespeare. He liked L and Lass. So, by overall, I think if you think about the fact that they have succumbed to what looks like the people's will, it's a good lesson for us that in Africa we are coming to grips with the idea that the popular will is more important than individual interests. Even in a case of Ethiopia where we have a dictatorship, and you know, Haile Mariam Desalegn took over from another dictator who expired through natural means. I think you can see that the most important thing is that some forces which look bigger than his personal interest forced him out. Same with Zuma. He was desperate yesterday, explaining. He went out, and I think it's good for Africa because we have this big man syndrome, which makes people not quit even when they have expired. They are used by debt dispensation. So I think it is good for Africa.
All right, Steve, for Kenya and for Africa, lessons?
Yeah, I think what is documented is Africa's resilience and ability to solve its own problems without external intervention. Very huge lesson, particularly for Kenya. There was no external intervention, no pressure. Sometimes external pressure achieves the reverse result of hardening oppositions.
Right.
But then also, we also want to interrogate the party structures and the party systems in South Africa, because you see, the precursor to Jacob Zuma's resignation was that he was recalled. First of all, Cyril Ramaphosa was elected as the ANC president, consequently rendering Jacob Zuma officeless. Then as a result of that, he was recalled. I think that is something that political parties may want to reflect on with a view of strengthening the institutionalization of political parties. A very important thing. Let us not have parties collapsing every other 5 years. I think with that, we may learn something.
All right. We now want to go to our headline topic tonight, which is President Kenyatta making good his threat to revisit the judiciary and what that portends for law and order. First, let's look at it politically. Prof, is this a good move, what we've been seeing the president doing? We see JSC being reconstituted, State Law Office reconstituted, this scathing letter by Raphael Tuju to the Chief Justice of the Judiciary.
I think there are some worrying signals coming on, because if you listened to what the president said during the inauguration, he struck a reconciliatory note, and everybody thought that he had even forgiven the judiciary, whatever disagreements that went on between him and the judiciary. But now the signals that are coming out in terms of changes that he has made at the judiciary, it looks like he's now putting in place men and women who could do what he wants done. And we hope what he wants done is for the good of the whole country, because he announced that he wants to be the president of everybody. But now, looking at the letter that Honorable Tuju has written, first of all, some of the issues he raises can also raise very serious legal arguments. And I think if you go to court, especially the first issue about the election, people can also give different contrary opinion. So the best way to do it is probably to get to the Supreme Court, again, litigate over that matter, go over that matter through the legal process. But when he writes like this, one gets the impression that he's using executive authority to intimidate the executive, which is not politically good, because as you know, our country is a bit divided, and there are people who read that probably he's using his power. And Anne, I want
well, I mean, how much power? He's just the party secretary general.
Delegated authority. In fact, you should know, Anne, that every man and woman can survive some adversity. But if you want to know the true character of a man and a woman, give them power, and you see what they do. So this is the kind of character we are seeing. He might be using what you call delegated power from the executive, but politically getting to your question in a precise way, does it do anything good? No. Our country is divided. We don't want this kind of letter. We want statements from the executive that can unite the country, can tell people to forget the disagreements we had during the elections, so that we can talk together. Even if we didn't agree over the elections, even if we didn't vote in the same way, we need to come together. So that is the problem.
So first move should have been something towards reconciliation.
Yes, not this kind of letter. It causes more divisions and more tension.
Fair point. Steve, look at this if you would with me, and I just want to show you some excerpts of this fairly long letter that Raphael Tuju penned to the Chief Justice, and I'm just going to quote some of the sections to you. Other than the fact that you've already seen him referring to or rather castigating the CJ and saying he almost burnt the country, he also brings out some case studies to make his point. He starts with Petition 1 of 2017, Raila Odinga versus Uhuru Kenyatta and others. And this was, he says, an attempt to get the clarification on the fate of the 26th October repeat election after NASA had made their own decree on several occasions that there would be no elections. He goes on to say, quote, the Supreme Court saw nothing urgent about this petition to the court and gave a hearing date of 27th of October 2017, a post facto date, a naughty wink to NASA to continue with their contempt of the Supreme Court. Then he gives another instance, citing what happened after the Jubilee win of the 26th of October 2017, saying ODM and NASA continue to defy that ruling by publicly stating their refusal to accept the ruling and organization of a disruptive economic activity through demonstrations and a quote-unquote swearing in. The swearing in is in every sense a contempt of the court ruling that upheld the election of President Kenyatta, and the Chief Justice has not found it necessary to address this. Tuju goes on to refer to the Attorney General who brought forth a matter seeking direction on a matter of 30th of January 2018, but the busy judiciary did not listen to that matter. Instead, the court set a date and time in the middle of February 2018. The court did not deem it fit to certify this matter as urgent, in contrast to a certification of urgency when ODM and NASA surrogates had come to court in an attempt to postpone the 26th election. So there we have it. Perhaps just one more issue that he raises as case in point is the Kitui petition number 7 of 2017, Counties Development Group versus the Attorney General and 3 others, where the court found basically that ODM and NASA should suspend the formation of the People's Assemblies, but he continues to say they've continued with impunity to disobey that order. Therefore, seeing that as evidence, Steve, does Jubilee have a point? Does it appear that the courts are not playing even-handedly?
I think let me start with the beneficial aspect of this letter. It exposes the gap of knowledge between the process in court and how the process are communicated to the greater public. Because Kenyans are litigious in nature, they go to court every other time. I think courts must now begin to explain with more clarity beyond what they tell lawyers, because cases stall in court partly because the lawyer's responsibility, their absence, and partly because how judges have also prioritized those cases. So I think there is need for communication or some form of explanation how case management is done. Then number 2, there has to be an understanding that we have appeal processes. If you're not happy with a high court judgment, you can go to the Court of Appeal, and subsequently even to the Supreme Court. So I think insofar as the letter displays some ignorance of the court process, I think that is something the court can address. There is also the other issue of non-compliance with the law, which is a valid point. You see, the Kitui High Court petition, when the court says do not establish any more assemblies, and that order has not been reversed, I think what Tuju is trying to, it's a burden is trying to impose on the judiciary. It's not necessarily the judiciary's role. The judiciary is to interpret the law as it is. Once they have interpreted it, then it's up to the Kenyans to organize themselves in compliance with the law. So if NASA fails to comply with the law, and there is no subsequent application before the court, there is really very limited. I think what is trying to challenge that maybe the Chief Justice should have been also equally generous with his comments and said, I think there's a breakdown, there's some breakdown in the rule of law. NASA is not observing court orders and Jubilee is not observing court orders. But the question of observance of court orders is a question that is external to the judiciary. But I think the third issue, which comes out in that letter, and is a point of concern, the letter carries some weight, some voice of authority. You know, in terms of, it sounds, there's a tinge of arrogance in the letter. It's like Tuju is trying to, you know, when he's comparing the Supreme Court judgment, Raila Odinga decision, and the High Court, and he's saying, listen, the High Court judges are not even using the Supreme Court Raila Odinga judgment, you know, that reversed the presidency. I think that is covertly abusive and disrespectful to that institution. Lack of respect doesn't mean that you say, I respect your court. It comes out in totality that this letter is...
And that is a fair point. Perhaps there may be a tone that, you know, some would take exception to, but at the end of the day, the most important point, are they proving a point? Has the Supreme Court appeared not to be even-handed? Yes or no?
No, that question, Anne, cannot attract a yes or no answer directly, because you must look at the nuance. What I think the court must do is
Do they
this.
have a point?
They have a point, the extent that, personally, I have handled cases that have not progressed up to now. Other cases that I've been involved in have gotten quicker dates and have been concluded. You get, it's now incumbent upon the judiciary to communicate case management to the parties and to the greater public, especially those matters that have a broader public interest. Remaining quiet or maybe communicating to lawyers will exclude the litigants or the beneficiaries, the intended beneficiaries of that litigation. I think that is a good point that must be addressed.
Okay, Kibe, but beyond making any possibly substantial points about the way in which the courts have made their decisions or carried out their business, including scheduling of matters, etc., does this letter go beyond that to prove that there is further notoriety, like the courts are in cahoots or are beholden to NASA?
In many ways, reading the letter, if one can excuse what he calls the tone and the arrogance, sometimes that is his style. The content of the letter is largely true, and I agree with it. Those cases that he has given, if you look at it last year, and I actually did some long article on this particular issue sometime last year, the cases dealing with elections, there was a tendency in which NASA ended up winning more or less like 20 cases, important cases to do with last year's elections, and culminating with the nullifications of the elections on reasons that were not very convincing. Now, the cases filed by Jubilee, and I happen to have filed 3 of them, 2 of them actually NASA did not even defend. And in both of them, you could see that the judges, one in Nakuru and one in Nairobi, when you read those judgments, it's like NASA was in court.
Which
arguments were made.
are you referring to?
There was one about IEBC, the issue of IEBC when they wanted to be removed. There was another one of David Kosing in Nairobi. And when you read both those arguments that were being made, we presented arguments. Those arguments were unopposed, but the judges ended up coming with arguments that could have been made by NASA if they had come to court. And therefore, the point I'm making is this. I don't have a specific problem with any case. It's for judges to decide cases well or not. But the impression, if you now give to Jubilee the impression that they did not have a square deal in court, that's not good for the judiciary. Personally, I am completely unable, and I want to go on public record saying this. I am not for disobedience of the court orders in any manner whatsoever. But it is equally important that the judges must remain objective, must remain even-handed. Because now the perceptions where instances are given, where you can say it is factual, you've not been even-handed, then it would be very difficult for the judiciary as an institution to be able even to be defended by people of goodwill that they should be obeyed. And therefore it is also in the interest of the judges to ensure that moving forward, we try as much as possible not to destroy the institutions that is still a young institution so that it can play its constitutional role properly. Let me just say one point. I can give an example of the Supreme Court of Pakistan. The Supreme Court of Pakistan is in bed with the Pakistan Army. And when you see the kind of decisions that they do, and also in Egypt, you also have again the same problem. So that the problem can be, you can be in bed with the regime, and you can also be in bed with the opposition. None of it ends up well for the country.
Right.
Because remember, and I'm afraid for Kenya, in the Maldives, the only other example you are being given of a country where the elections were nullified. When you read what is happening in the Maldives, they have not recovered from there. And the Maldives might go to the dogs because of this nullification. So I hope Kenya does not go the way of the Maldives.
But Prof, the same question, does this letter may suggest, and I don't know what your opinion is, perhaps the Supreme Court hasn't really appeared even-handed, if you do agree, but does it go further enough to prove any undue collaboration with the opposition?
I don't think so. I have totally no evidence that the judiciary could be colluding with one faction in this political combat. But I think what I am sure of is that in any litigation that appears across the world, it's not even in our country alone, those who lose, even in a football match, they will always blame somebody. So in cases of the judiciary against the people now, already there's a judgmental attitude that if I lose, probably the referee was wrong. Or if I win, the referee was right. So what we really need to do in this case is to exercise a lot of restraint. Some decisions will not favor us, and we shall have reasons to explain. And some decisions will favor us. So every time decisions don't favor us, are we going to condemn whoever made the decision? This is what is, there is some civility which is lacking on the side of the people, on the side of the combatants, NASA, Jubilee. They expect everything to go their own way. And this is why we need a give and take approach. And that is really what I started with Anne. These decisions will never favor one person for a very long time. We must appreciate that there is some good even in our worst, and there is some evil even in our best. The people we deal with in this country, our friends, our relatives, could do certain things that we don't like. A father could do something that you children don't like. But you cannot dismiss them just because they took a decision that you didn't like. We have chosen a constitutional process. We want the courts to arbitrate disputes. And when the courts do that, sometimes they don't favor us. Sometimes they do us. So the positions that are being taken and the tone you are getting that letter has this impact. Usually, already there are supporters of political factions. Does it help to reduce the gap? No, that is the point. So we really think that this kind of letter itself gives the impression that the judiciary is colluding. In my opinion, we don't have that evidence.
It doesn't prove it. But let me ask you this, Prof, because I do understand what you're saying about, even in our good there is some bad, etc. But when the stakes are so high as they are in this country, as it was in the run-up to the election, to the repeat election, to a swearing in of Raila Odinga and what that could mean politically, I mean, does the severity of the situation not move a step further beyond just saying, okay, we don't like some of the things you did? I mean, does it warrant the severity of this letter and whatever it may or may not be priming us for?
You see, at the point where the rulings were done and some judgments were made that we didn't agree with, under this same constitution, running from Article 19 to 58, we have a Bill of Rights that allows people to express themselves. And I think a lot of people have expressed themselves and given opinions about this ruling. But now when you pick a pen and a paper and start writing, several months after that, you start writing directly to the head of the judiciary to express that kind of sentiment, you are opening wounds now. You are officially complaining that this, you are going to bet with so and so, and I now want to remind you about it. We thought in the severity of the situation where you say, under the elections, we know that during the elections, tempers are high and people can say anything. And people express an opinion. But right now, where we are in our country, we have sworn in a president. We really don't want this kind of thing. What they are saying, as you put it, confirming that nobody has forgotten what went through in an election. So if elections come and we disagree and people don't forget, we don't even forgive each other, what direction are we taking this country?
No, Prof, I completely hear you on the need for reconciliation. I suppose what I'm saying is that we have gone past this just being a swearing in. There's another swearing in that has taken place.
Yes.
And I think we're looking at this letter in the context of a more severe dynamic. But I do hear
he answered the question, and I would like you to say, even the swearing in that came in, and even the count assemblies, we can even discuss that. The point we are saying is that the judiciary has made a decision about that one case in Kitui. Now, it pronounced itself on the matter. If one faction was not happy with that, did they exhaust the Court of Appeal? then the Supreme Court to ventilate over the same matter, or they just kept quiet after somebody violated some judgment in Kitui and they just kept quiet. If you keep quiet, you don't understand our legal system, because there were still avenues to do that.
So
and
NASA is also disobeying court orders? Is that what you're saying?
I think disobedience of court orders, I have even spoken before, has been on both sides. And you know, you cannot say, you cannot sit here and pretend that only the government has disobeyed court orders. We have seen cases where NASA has also done the same. And that's what we are saying on this discussion. We don't want anybody. Even when the temperatures are so high in a political environment, there is no option. Everybody must obey court orders. Whether you are in government or you are in the civil society, you must obey. And NASA has done it, government has done it, but we're now asking, with this kind of dispensation, how long can it go on? With the
I think the anger behind this letter, it is also good to be fair to Jubilee and understand it.
Yes.
From the reports of the petitions that were filed, from both the Jubilee zones and in NASA zones, the courts are holding that the elections were held largely, they were credible. And as of now, we've not seen any election petitions succeeding in a serious one. And therefore, for the Jubilee, the anger is that you go out, win an election with 54%. After you've won an election with 54%, it is nullified without very convincing or credible reasons. Then you go for a repeat elections that ends up questioning your legitimacy. So that now you must understand them to be saying that the political crisis, which we can never deny we are facing, that has also culminated in a swearing in that we are having right now, has been triggered by Maraga. Of course, that may not be that he set out to do that, but they also are cause and effect. That when you look at, when you trace back, you go back to a situations whereby you can be able to say that a lot is traceable to the nullifications of the elections at that particular time. How Jubilee reacts, I'm not saying, I'm not endorsing the manner of their reactions, but it is definitely that was a deep grievance. That deep grievance is yet to heal. I don't know what the revisiting will entail in the fullness of time, but we have to understand and take some share of responsibility that when on a serious issue, you trifle with it, then you can, like Michuki said,
if you rattle a snake,
you might end up rattling.
As the media, we have very soft feelings about that statement. Never mind, we've just been switched
not
back
endorsing
on.
it.
Don't take me down this road.
But again, I'm just saying,
Fair
it's a
enough.
scenario
You've made your point. You've made your point. I don't want to head down that road. Steve, let me pose it to you in a question, because I know you do want to respond. But you've heard from what both Prof and Kibe have said, and there is now what some scholars are putting out there as a, quote, doctrine of civil necessity, that because of how the court ruled initially, overturning this election, and, you know, the things that have followed thereafter, and possibly the fact that perhaps the court has not been even-handed, that Jubilee has a right to ignore court orders. You're wearing a yellow ribbon.
Yeah, I'm going to explain that.
Yes.
I think the doctrine of necessity should not be misplaced or misapplied. It's a facilitative doctrine. It's not an inhibitive doctrine. But I think what is critical to underscore is this. We may pontificate until the crack of dawn, but the issue that should not go unattended is the unity of the Constitution and the structures under it. Now, and I think this is what even Tuju ought to have demonstrated. You see, structures under the Constitution and the office holders of those structures, those institutions, the Constitution does not prohibit consultation, concurrence, deliberation between the political wing of government. Express your concern to the judiciary. Is there evidence that the executive or the legislature have expressed concerns? If the courts are continuously overturning legislations, for instance, is it not a point of concern? Where are we getting it wrong? Is there some diversion, some sort of lack of coherence in legal philosophy, for instance, because you're passing laws that are consistently being struck as constitutionally offensive, or you're making decisions that are being reversed at the courts? I think it would not be argued as illegal or unconstitutional if the political wing of government had a shared understanding with the judiciary and said, listen, this is what we're trying to push. This is our agenda. Explain to us so that we can adjust. You know, that consultation is permitted. We need some semblance of symbiosis within the three arms of government. So before Tuju comes out in this forceful manner, has he exhausted? No, right now government is talking about solving problems within formal institutions and formal structures. Have they adopted that structure? Can they explain that concept? Because you see, when government should not compete with opposition, political opposition, in breaking the law or in whining. Because you hold the instruments of power, the constitution rests upon you to implement it. If you think the design of implementation does not match the expectation of the judiciary, what is it? Can you then discuss and have a shared and settled or harmonious approach in the legal philosophy? So I think that is
they should have been sitting and talking together
they should have done
and
that before.
Things out without letters.
Yes.
In addition, just a small ride on what my friend Steve is saying. Another bit of it is because the Jubilee administration has power. One of the things that I would request them to do is to sit down with its legal team. Whenever a reaction comes or a response comes over some matter of public interest or national interest, do they have the correct legal team to give the correct interpretation of situations? Because maybe one of the problems is not because Jubilee is wrong, but the problem could be that the legal team that they have around them makes certain errors that make it very easy for the courts to do what they do. And in that case, even the public does not need to hear that. It should be part of the consultation process. First, some housekeeping within Jubilee, and then what is now talking about an intergovernmental consultation, so that we save ourselves this kind of letter coming out and polarizing an already divided country further.
Okay.
Yes.
Speaking of housekeeping, that already is happening, of course, with the exit of the AG and Solicitor General and the replacements being named as Justice Kihara Kariuki, pegged for Attorney General, and Ken Ogeto, Solicitor General. To both you, Kibe and Steve, what do we know, especially, let's start with Justice Kihara, in terms of past rulings, his jurisprudence, and what his possible leadership at the State Law Office would look like?
I think Justice Kihara is a very important site for intellectual rigor.
Okay.
Yes, he has demonstrated his capacity. He has an established capacity for developing jurisprudence in a very coherent manner. So I think he'll do a good job wherever station he is. What he may have to balance, which I think the outgoing AG failed, understanding the different spaces in which you work. You see, Professor Githu Muigai excelled as a teacher of law, and he excelled as a practitioner. But you know, when you're interpreting the law for political actors who must apply it in a very indisciplined setup, part of the greatest threat in this country, other than the disobedience of court orders, is that we are a very indisciplined lot, and politicians are harnessing that. The manipulation of the law is hardly surprising. It's very depressing, but hardly surprising. What NASA has done and Jubilee has done in the past is a continuation of what we have now. You see, now we should have transitioned. But for me, I look at what NASA does sometimes with amusement, because we can list instances of outright disregard and disobedience of court orders, and what also look like threats to the judiciary. When Raila himself said, well, we don't want to go to court, but we want to give you an opportunity to correct what we did in 2013. You see, that went unattended. But now, when it's convenient,
yes, made that statement just before the court
I hope Justice Kihara will understand the nuances of governance in an emerging democracy. Part of the challenges of our democratic setup is that it doesn't rest, truly speaking, it doesn't rest on sound constitutional and legal principles. We may instead evolve into what you may call an ethnocratic society, where people organize their affairs. The philosophy is what your region cares for. If so long as the people in NASA, maybe the people in Jubilee, as long as they are mainstreaming what their communities and their regions care for, they really don't mind whether that issue is outside the law, and they don't want to be reprimanded, to be called out for. That, as Attorney General, as the principal advisor to government, what I would like to suggest to him, let him urge fidelity on the part of government, because ultimately, at the end of the day, it is government that holds its key institutions. They're the one that preside over key institutions of governance. They must lead by obeying the law. This is what the Yellow Ribbon is all about. It's not about political activism. It's about reclaiming the Constitution as our article of faith, making sure that every ordinary Kenyan, lawyers and non-lawyers, political actors and religious leaders abide by the Constitution. That is what our laws have ordained.
What do we know of Justice Kihara and his jurisprudence, and how would that affect leadership at state law?
I think, let me say this, that Justice Kihara, his resume indicates that he's been a lawyer of good capacity. I've appeared before benches before him, particularly in the Court of Appeal. Looks to me a firm and fair person. But talking about, since he's an established professional, I believe that, strictly speaking from a professional point of view, he has the technical capacity to be a good Attorney General. But talking about his jurisprudence, I think there's an element either of some luck. To say Justice Kihara is not one of the judges that you can be able to say, like Justice Odunga, you can, like Justice Githinji and Justice Ojwang, whom if you are told to mention 5 cases decided by Justice Githinji, and those are the judges you can be able to give, it is not easy to come across and say, this is a great judgment by Justice Kihara. And probably it may be explained by the fact that he had a short stint as a High Court judge, and then when he went to the Court of Appeal, I think probably I was unable to pick his writing style. You can easily pick the writing style of Justice Ojwang, Mr. Kathuriman Toinoti, Justice Kiage, even Justice Musinga, and say that in these judgments of the Court of Appeal, you can be able to see the influence of a specific judge. It is not easy to pick him out. And therefore, as he goes now to, but as President of the Court of Appeal, here he was a good leader, and which is a positive as a leader, that he will take it there to the state law office. But now going to the state law office, I think for purposes of his legacy, I think the place where he really has to establish himself, even professionally, really in my view would be his stint in the state law office. And having said that, I don't think I can envy either him or the new Solicitor General, for the simple reason that they are taking over those offices during extremely challenging times, when the president is being urged by some people to become a benevolent dictator. And of course, it would be the role of the Attorney General and the new Solicitor General to ensure that, as the guardians of public interest and constitutionalism, that we do not transform this country from a democracy, albeit a troubled one, to a dictatorship. Now, that would mean that they are starting off with some fair measure of trust by the president, something which Professor Gedu seems not to have had sufficient.
I want to ask you something.
And therefore, yes.
You are a very distinguished lawyer in this country, so maybe you can ask me. I don't know whether you talked to Justice Kihara, but we need to establish whether Justice Kihara had a meeting with our president, and the meeting probably went like this: Mr. President, do you want me to work with my independent mind, or you want me to leave my mind in my house and work with your mind? If that, because that is very interesting. Justice Kihara must declare that openly, so that if he fails, we understand the agreement he had with the president. Because across the world, you know very well that posts of attorneys general are actually political posts. Even if you are a lawyer, sometimes some leaders will advise you, forget about what you learned in the university and what you are doing in the corridors of justice. Now you have no mind of your own. But in some cases, you might find that they tell you, take decisions and do it this way. Some of the people that you are blaming, you have seen them even being appointed, some people appointed as cabinet secretaries, very distinguished people. Just after the formation of this cabinet, some professors in the university, under the coalition government, the worst performers were people with a distinguished career in the academy. And so you ask, what happened? the political influence on the way people perform jobs is amazing. So let us not judge, say that we don't question. I don't question the integrity of Justice Kihara.
Nobody has, by the way.
But I don't know whether
He'll be able to take his mind to work.
He will take his mind to work, or he will work with somebody's mind. If it's with somebody's mind, he will fail more than Githu Muigai.
I think his
Actually, the point I was
is
making,
firm and intense, and that is what that is his nature. If he carries that
It's firm and
intensity,
intense.
if he carries that intensity and firmness, he'll be able to work independently. Actually,
He could be sacked.
no president wants a make attorney general who is manipulable, because then you don't become a reliable person in terms of giving solid advice. If you can't organize your thoughts to match the expectation of the recipient. So if he's able to maintain his independent mind and the clarity of thought, then he'll serve the government and he'll serve the country better.
Okay, so I think that the panel is saying you'd like the good judge to take his mind to work. But finally, because we just have under a minute to talk about the changes at JSC and in the context of revisiting the judiciary and perhaps fixing it. What do you think of this chess move, Prof? How substantial is it?
I think, in my opinion, the changes that have taken place, people are reading too much in that. One of the things that we really expect the president to do is to put in place a team that will help him achieve what he set out in his agenda. So to look at his appointments as a way, conclude that this one is going to fix so and so, is, I think, out of order. In my opinion, we have no evidence that the president is doing that in order to hit at somebody. My interpretation of what the president is doing is that he's picking certain people that he thinks can pursue his agenda, especially the four items on his agenda that he wants to achieve. And probably he thinks that there are some loopholes within the legal system that were not fixed by the earlier team. And those loopholes are not about fighting people, in my opinion.
But this is a team that hires and fires.
Yes, it has to advise, but do you think it is the agenda of the president to receive advice to hit at people? I think it is his agenda to make sure he achieves the 4 items that he announced to the nation. So he wants every place to have strong people he can trust. But if we reduce it to the fact that he wants to put 3 people to hit at Maraga, probably that is overstretching our imagination. Let it come out that is really what he wants. Then we shall ask Mr. President, we shall say, is this your mandate? Your mandate is to form government, to deal with our problems in this country, not to fix people, individuals that you don't agree with. And I do not have evidence that he's fixing anybody through this.
All right, fair point.
Yes.
I think the JSC is a statutory, it is a statutory organ, and by its own formation, it's susceptible to various interest formations. The LSK has a representation, the president has nominees there. That is how it's designed. So, I mean, when you are selecting, when the law society is sending a representative, you pick someone whom you think will best represent the interests of the society, and it shouldn't be surprising or an issue of concern that the president sends people that he believes in. So that's okay. What the challenge they must maintain, the challenge they must overcome is that they must work independently and apply their mind. You know, when they're interviewing and selecting and nominating judges for appointment, that they must do, because it's a statutory organ. Is intended to work independently. But you know, at the point of entry, every person, every institution has a role to play in terms of donating someone. So for me, I wouldn't want to read
Article 249 should guide them.
Fair enough. Quick final comment?
Well, the final comment is that as the president begins his final term and he has to face all these challenges, he must remember that the notion that there is something, the judiciary there, parliament there, and executive there, is really a misconception. The president is head of state and head of government. As head of government, you are responsible for the judiciary, ultimately, and for parliament. You must ensure that in parliament there is good and open debate, that can enable members of parliament to contribute to nation building and to discuss the problems of the country. As a judiciary, you must ensure that it lives to its independence. It is made of, it comprises capable lawyers, men and women, and to ensure that it is fair to everybody. All those you must do as head of state. The temptation to say that you can have some kind of refuge, you can recourse to some kind of benevolent dictatorship, which essentially means ignore the constitutions. It is important for the president to know, and his true friends to acknowledge, that the only reason why he is president of Kenya is because he assumed that office on the basis of a process prescribed by the constitutions. If that be the case, the constitution that has given you an office and commands us to obey you, it is not possible for you and for anybody else to say that the same constitution should be ignored. And therefore, for me, I pray and hope that he will be wise and resist the temptation and the idiots saying you should become a benevolent dictator.
They should be taken away from him.
Let's wind this conversation there. Take your mind to work, folks. Thanks, everybody, for your time and your views. That's ours. Good night. God bless.